thank you everybody for coming out today. Last day of the semester, for most people. And hopefully you've enjoyed your semester and you're ready to get into finals. And we appreciate your time for coming out to talk about originalism today. I want to make a quick announcement though. We've had the election for those of you who are members. And our e-board for next year is going to be Zach Dukoff, our new president. And his VP is going to be Mary Erickson, and she's on her way. Unfortunately, she's not here yet. But they will be selecting a new treasurer and secretary, and the club will live on. So that's wonderful.
Good.
And another round of applause for Rich for actually hosting this event. Thanks a lot.
So I want to welcome you guys to Federalist Society Pace Law School's final event of the semester. I want to tell you guys a little bit about the Federalist Society. So the Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and has empathetically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. This entails reordering priorities within the legal system to place a premium on individual liberty, traditional values, and the rule of law. It also requires restoring the recognition of the importance of these norms among lawyers, judges, law students, and professors. In working to achieve these goals, the Society has created a conservative and libertarian intellectual network that extends to all levels of the legal community. And today we're here to have a discussion about originalism. What is it? Does it matter? If it does, why does it matter? If it doesn't, why does it not matter? Should it be used by our judiciary, or should they use other methods of interpretation? And we have two fantastic scholars with us here today. We have Professor Josh Blackman, who is an associate professor of law at the South Texas College of Law, Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He is the author of the critically acclaimed Unprecedented, the Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Professor Blackman was selected by Forbes magazine for the 30 under 30 in law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute, and is founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and blogs at joshblackman.com. Professor Blackman is the author of over 4 dozen law review articles, and his commentaries appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications.
Thank you. Thank you.
With us today, we also have our own Professor David Dorfman. And before joining Pace Law School in 1995, Professor Dorfman taught lawyering skills and techniques at NYU Law School. From 1987 to 1993, he was a criminal defense trial attorney at the Legal Aid Society Criminal Division in Brooklyn, New York. Professor Dorfman brought many cases to jury and bench verdict while defending many other criminal clients through pretrial hearings and final dispositions. He wrote numerous motions, briefs, and memoranda of law. Prior to law school, he received an Art Critics Grant from the National Endowment for the Arts. As a freelance writer, he wrote both for publications and for grants, specifically on arts criticism and aesthetic theory topics. Here at Pace, Professor Dorfman teaches and supervises the Barbara Salkin Criminal Justice Clinic, which represents indigent defendants charged with misdemeanor crimes in the County of Bronx. He also teaches doctrinal courses specializing in criminal law and criminal procedure. So we'll jump right into it, and we'll have Professor Blackman talking about it.
Thank you so much. It's a pleasure to be here. My first time at Pace Law School. I am from Staten Island, so this is very close to home for me. Also, Professor Dorfman, thank you for taking time every busy day to join us. The topic here is originalism. Nothing I say today will be original, no pun intended. My remarks are based in large part on the works of people like Larry Solomon and Randy Barnett and others who've been writing about originalism for many, many years. Originalism is based on a very simple idea. The court is bound by the original public meaning of a constitutional text. Okay? What does that mean? Public meaning. How would these words have been understood by the public at the time the Constitution was ratified. The original public meaning is the meaning the words had in the past. They may not still have that meaning today. Meanings of words change. For example, in the Constitution, the phrase domestic violence is used. Right? At the time of the framing, domestic violence was used to mean insurrection, rebellion. Today, if we use the word domestic violence, it means spousal abuse, right? Chaos in the home, neglect. Words change meaning, and we can chart how the understanding of words have changed. But an originalist will say we stick with the words that are in the Constitution as they were understood. The Supreme Court should not have the power to change or amend that meaning, right? This is a notion of living constitutionalism. I believe that there's a process for changing the Constitution, which is called an amendment, not through a case-by-case basis. A lot of originalist theory is relatively new in the last 3 or 4 decades. But originalism itself is not new. Going back to the time of the framing, those who helped draft our founding documents understood these principles. For example, in 1791, Alexander Hamilton said, quote, "Whatever may have been the intentions of the framers of a constitution or a law, that attention is sought in the instrument itself, according to the usual and established rules of construction." Thomas Jefferson also asked, what is the intent? How would those who draft this document have understood a given principle? So there's nothing novel about originalism. Okay. To state originalism is easy enough. Now, a lot of people have misconceptions about what originalism is. And there are 5 myths that I want to address and to debunk. So the first myth, which you hear very often, is that originalists are James Madison. Or the same way you have a seance with a Ouija board, right? How can we bring James Madison back to life and ask him what he thinks about contemporary problems? That's not true. Originalism is about text, right? No originalist around today asks, what would James Madison think? What matters is what the text means, its public meaning. We don't need to know the mental state of the framers, and indeed, James Madison was not the only person. He was one of many people involved in the drafting of the Constitution. There were people at the Federal Convention. There were people at the state conventions. There were people in the public who wrote articles and pamphlets. So focusing on one person to figure out his intent is not very productive. Instead, we try to figure out the broader meaning of text. The second myth that you often hear is that originalists cannot apply the Constitution to new circumstances. So for example, when the First Amendment was drafted in 1791, we didn't have the internet. We didn't have computers. Today we do have these devices. But this is not a problem for originalists. We can apply the freedom of speech to new technologies. Speech is speech, whether it's in person, on a piece of paper, on a printing press, on a amplified speaker, or transmitted over the internet. The Constitution was drafted in a way that could be applied to new circumstances. Easy example, we have lots of new states that were not around in 1789. There's no question that those new states get senators, even though states didn't exist at the time. You apply the text to what new circumstances prevail. So that's myth number 2. Myth number 3, and this is the one you see very often, especially in Senate confirmation hearings, that if originalism is correct, Brown is wrong. It has to be overruled. And there's been a recent pattern in confirmation hearings where every single senator asks a nominee, is Brown v. Board correctly decided? Now, they always dance around that question. And the reason why is the follow-up, right? Is Brown v. Board correct? Yes. What about Roe v. Wade? Right, that's a follow-up. And they can't answer that one because then they get in trouble, right? But there's actually very good historical arguments that Brown was actually correct as an original matter. If you read Brown, Chief Justice Warren says, well, at the time of the framing, there were segregated schools in the District of Columbia, which means, of course, the framers would have been okay with segregation. Not so fast. I think there's a lot of counter-arguments about laws passed in the wake of the 14th Amendment, which recognize education as a privilege of citizenship. And I think the Privileges or Immunities Clause of the 14th Amendment is a far less segregation prohibitions than even the Equal Protection Clause. Indeed, the decision I think is inconsistent with the original meaning is actually Plessy. The separate but equal doctrine has no basis in the Constitution at all. In fact, it reads portions of the 14th Amendment right out of the document. So again, originalism doesn't have to be inconsistent with some of our leading precedents. Indeed, I think John Marshall Harlan's dissent in Plessy was far more originalist than was the majority opinion. Okay. The next myth is inconsistent with precedent, so it has to be bad. Our courts are built on a system known as stare decisis, right? And I think the concept of stare decisis derives from the judicial power itself. Courts stand by their precedent to create continuity and stability in the law. Now, I will agree that there are a lot of precedents from the U.S. Supreme Court that are not originalist, where the justices were engaging in notorious exercises of living constitutionalism. I'm not going to disagree with you. And were I an originalist justice, Lord help all of you, right? I think I would behave probably a little bit differently in stare decisis than my colleagues would on the court. But any sort of movement I think would be gradual. And I think the democratic process would have an opportunity to react. If the Supreme Court reaches a decision that people don't like, they can change the law. And it doesn't require constitutional amendment. In some cases, it's as simple as changing a statute. If you think the Constitution protects the right to same-sex marriage, then enact it through your democratic process. You don't have to wait or rely on the courts to enact that. Okay? Now, those are some myths about originalism. Next, I want to talk about the alternative, right? And it's somewhat binary to say that the alternative to originalism is living constitutionalism. There's a lot of gray in the middle. But I'll use this sort of binary approach to make it easier for this brief discussion. Okay? Living constitutionalists believe that the Supreme Court has the power to interpret the Constitution in ways to adapt to a changing society. I view this approach as asserting a power to amend the text without an amendment. Where do courts get this sort of power from? Well, it's not in the Constitution. Perhaps it's a power they've sort of adopted over years. But this is not something derived straight from the text. I worry very greatly about having justices who sit as a super legislature and have a never-ending constitutional convention where 9 judges can simply change the Constitution as they see fit. I think there are other ways of making these sorts of change. Okay? There's another reason why I prefer originalism over living constitutionalism, and this one's a bit counterintuitive. It's premised on the notion of democratic legitimacy. Right? The Constitution was ratified back in 1789 by a supermajoritarian process. It was ratified by representatives of we the people. And to change it is fairly onerous. There's a 2/3 vote in the Senate and then 3/5 of the state legislatures. This is very hard. But the fact that it's so hard to change the Constitution is what confers legitimacy on the process. This is something that's meant forever. Now, I'm ready for your objection. This process is flawed. In the late 18th century, when the Constitution was ratified, not everyone was included. Women, slaves, and others had no vote. Fortunately, we've gotten better. not all the way, but we've gotten better. With the ratification of the 13th, 14th, and 15th Amendment, the promise of equality was broadened significantly, including the right of franchise. Even so, the democratic legitimacy of the Constitution, I think, is greater. The Supreme Court has only 9 people. They are appointed for life terms. Impeached, but this has never actually led to a removal of a justice. I would much rather have, and much rather be governed by the supermajoritarian process than by the decisions of 9 justices who decide what the Constitution means. Right? In other words, originalism is not perfect, and I'll be the first person to concede that. But I think it's far better than the alternatives. Justice, it's the lesser of the evils. Okay, I'll stop there. Turn over to Professor Dorfman, and I welcome our discussion later. Thank you all so much.
Yeah. I don't know if you're going to be able to hear me, because I'm not sick, by the way. This is all allergies, so changing conditions.
You want to grab that mic, put it on your thing?
Yeah, because I'm not sure if you can pick me up. But this won't help you. This will only help the recording, right?
That's all that matters.
That's all I can.
It's all speech.
Can you hear me? Okay. So, I think we're all originalists at this point. I think Justice Scalia, for better or for worse, has had an enormous impact on this discussion, so that even people who might be, and I think caricaturized as living constitutionalists, really do start with the text, at least as the first step for constitutional interpretation. I don't think people are living in any way that truly rejects the constitutional text. And Justice Scalia, to some lesser extent, Justice Thomas, though he's not anywhere near as influential, has had an enormous impact on the judiciary, on the academy. Somebody like me, who, I'm a public defender by training. I argue constitutional law all the time. When I make my arguments, I'm always starting with the text of the Constitution, whether I want to or not. It is very important, though, to realize that even, and I'm going to use Justice Scalia because I think the intellectual, the most influential intellectual in this school of thought, as the best example of what even he called faint-hearted originalism. If you've studied his opinion, frequently, I wouldn't say abandoned originalism, but recognized the power of precedent, stare decisis, even when those rulings did not square up with an originalist interpretation of the text. He recognized that imposing an originalist approach to constitutional law could be extremely disruptive if it was done in a way that basically destroyed expectations over time. So he actually, and I agree with Professor Blackman, would argue that Brown versus Board of Education was not a non-originalist opinion. But even if it was, even it could be attacked on a basis of originalism. That's been the law of the land since 1954. There have been numerous cases that have followed Brown. And at a certain point, certain kinds of precedents become what we sometimes call super precedents. If you watched Judge Kavanaugh's hearings last year, he was asked the question, it was about Roe versus Wade, of whether Roe versus Wade was a, quote, super precedent, meaning even though it might be not grounded in the text of the Constitution, it's been the law of the land for so long, and it's been reaffirmed in part, at least, since 1971, 1972, that at a certain point, It's become woven into the fabric of American law. It's created expectations on the part of the American people. It is part of our law in a way that reversing it might create disruptions that would just not be worth the effort. We saw something like this happen with Miranda versus Arizona. In 1966, the Supreme Court of the United States holds that, when people are subjected to custodial interrogation, they have to be given Miranda warnings. And again, it is really not much by way of text that's based on. In addition to that, in 1968, a federal statute basically seeks to overrule Miranda, or by instituting what's called a totality of the circumstances analysis for voluntariness. You don't have to get into it. Jump ahead to the year 2000, a case Dickerson versus the United States. Group of people are seeking to overturn Miranda. And Justice Rehnquist wrote the opinion saying, no, Miranda may not be based on the text in the Constitution, but it is what he calls a constitutional rule. Justice Scalia did dissent in that case, and actually it was a very vigorous dissent. But I believe if you look at what Rehnquist wrote, kind of throw out some of what is questionable reasoning, what he really was saying was that Miranda was a super precedent. It had been the basis for citizen police encounters for so long. It was in the culture. Every time you watch television, you watch a police officer arrest somebody, Miranda warnings are given. Every state had done it. Every state police department was doing it. Didn't seem to have a problem. They were still getting plenty of confessions. Even the Department of Justice under Janet Reno argued in favor of keeping Miranda. So you end up with this phenomenon of, yes, we have originalism, and everybody in a way is an originalist, but everybody is also very concerned about stability and keeping out disruptions from the system, and that one of the main guarantors of that is stare decisis and precedent. Now, so I think Justice Scalia is the person who called stare decisis the, quote, practical exception to originalism. And what's interesting, and you guys who've taken evidence may know about this, there's something called the hearsay rule. But then there are all these exceptions. And if you realize, if you're a really good lawyer, and I think I'm a pretty good lawyer, I can pretty much get rid of almost every hearsay problem by, in some way, taking advantage of the exceptions. If you've taken criminal procedure investigation with me, you know there's something called a warrant requirement. But the warrant requirement is riddled with exceptions, to the extent that almost no police action, certainly in state courts, requires warrants anymore. Very little use of warrants. Now, that's not true in federal court, but it's certainly true in state court. So one of the things that you might ask, and I do ask this, is that, okay, let's say we're all originalists in the sense that the original text, the public meeting, is where we start. But if stare decisis is an exception, and there's so many precedents and super precedents that end up qualifying as practical exceptions, have we begun to eat away at the rule of originalism by the just sheer number of non-originalist opinions that we don't want to get rid of? We don't want to get rid of Miranda. We don't want to get rid of Katz, the legitimate expectation of privacy. Justice Scalia, even in the Jones case, the GPS case, if you've read that case, his opinion, as the majority says, oh, the police can't put a cue ball, a GPS on a car without a warrant because that would be a violation of the common law right of trespass to chattel. But he recognizes that there is another argument, and he grudgingly accepts that there was also a legitimate expectation of privacy that the person had in their car and their movements in their car. So even Justice Scalia was willing to accept, right, non-originalist precedent because he didn't want to see the system so disrupted by a very kind of rigid originalism that would just strike down precedent after precedent because it wasn't contemplated in the public meaning of the original text, right? So, and it's actually, by the way, useful to compare Scalia and his what he called faint-hearted originalism, which I really respect, and Justice Thomas, who does seem to have a much more extreme view of originalism, where he is willing to strike down precedents that people have been relying on for decades and decades and decades. But it does leave open the question of how strong a theory is originalism if it is so subject to these exceptions. Let's talk about a few more ways that originalism gets challenged and arguably ceases to be as strong a theory as it might purport to be. Another issue is that the language, and we know this, right? Everybody here is probably taking constitutional law. A lot of the language in the constitutional in the constitutional text is language that is vague, ambiguous, and what we call polyvalent, right? And those are three different concepts. Vague meaning literally kind of amorphous and we don't know what it means. Ambiguous meaning it could have at least two different interpretations. Polyvalent, different interpretations. And so then the question is, you can go to a dictionary and you can go to the common law and you can go to a lot of other contemporaneous documents, and you're still left with language like cruel and unusual punishment. You're still left with language like due process of law. You're still, now we're talking about the second framing in 1868, but you are still stuck with equal protection of law. Many of these terms are either vague, ambiguous, or polyvalent. That doesn't mean they're defective, but they do resist the sort of interpretation that we have a fixed and really coherent and clear public meaning that was the product of the enactment of that language, whether it's in 1789, or actually in the case of the Bill of Rights, 1793, or the second framing that happens, and this is also very important, in 1868, when the 13th, 14th, and 15th Amendments are enacted. That's another issue for originalism. How do they square originalists with the fact that there is the second framing that happens in 1868? Because as difficult it is to determine the meaning of the language in the late 18th century, it's compounded by how we interpret that same language, right, 80 years later, after the Civil War. And arguably, even though much of the language is repeated and just incorporated, once it applies against the states, you can make a very strong argument that that language has to be rethought through the lens of a different time. Okay? That's another problem. Then we have arguably additional reframing during the Warren Court period, when much of the Bill of Rights is incorporated in the states expressly, because in 1868 it's done implicitly, but it doesn't happen until the 1960s. Couldn't you say that's another reframing time? And aren't we bid to examine that same language through the lens of the 1960s? This is actually akin to something Justice Posner writes in Reflections on Judging.
Oh, Lord help us, Justice Posner.
Lord help us. And I'm not a big supporter of him, but in many other ways. But he does recognize something, that we live in an extremely complex world, and our legal system is very complex. And that one of the problems with originalism, when it is done in a very simple way, in a way that doesn't have sufficient flexibility, that it's just not a match for the reality of the development of our legal system, right? Whether it's from 1789 to 1868 to the 1960s. And that's a big challenge for originalists. I believe it's a big challenge. And it's not as simple as being able to analogize the speech. All right, speech, we spoke back in 1789, and now we speak through a screen, right? The fact is that there are things that have happened in technology, globalization, the diversity of our society, the complexity of our society, that really make a difference. So for instance, I teach criminal procedure. We didn't have organized policing in 1789. We didn't have organized policing in this country until the mid-19th century. Now we have organized policing. when you start talking about the constitutional guarantees that involve the interaction between police and citizens, I'm not going to get very detailed about it, but I see that some of the language, as well as and I'm going to use the word intent, and I apologize for it, of the language from the 1780s and 90s doesn't make a very good fit with our present reality. Now, it is true, we do have another device. We have the amendment process, but as Professor Blackman does explain, it is very difficult to amend the Constitution. Now, Justice Black, who was a strict constructionist, textualist, originalist type, who was more liberal than most of the judges who identify themselves as originalists, he was kind of a Jeffersonian, and he really believed in a very active amendment process. And that's, by the way, not crazy and foreign. New York State, we have the capacity to have a constitutional convention every 20 years. It's in our state constitution. So it is possible that we could have a much more vigorous amendment process. And if we had that process, it's possible that we wouldn't have a judiciary, a Supreme Court that would be so inclined to amend or legislate from the bench, because we would have a more vigorous and kind of direct way for the public to influence its own constitution. But unfortunately, we don't have that. And the last, I think, I'm not really keeping track of time, and I apologize for this. The other problem we have is we have a major problem with our democratic processes. The other way we could be doing better in solving problems, for instance, without having judges do it for us. The problem is that for originalists and for people in general who buy into the design of the system, the assumption is our democratic process, our electoral process, is the preferred way, right? That we make these kinds of broad policy changes and ways we live our lives, and that it be the result of a truly majoritarian approach. But as we know, because of gerrymandering and because of the effects of money in the system, and the fact that certain states have more power, even though they have less people, they still have 2 senators. You know what's going on in our politics, and what's going on in politics right now is not unique. It's happened for a long time. It does create certain ossifications, certain rigidities that makes it very difficult for our legislative process to problem solve. And yes, unfortunately, that plus the fact that the amendment process is so onerous does, I wouldn't say force the judiciary, but it certainly encourages the judiciary to take on a problem-solving role, okay? And you did start seeing it in the Warren years. You did start seeing it in Brown versus Board of Education. Because guess what? The governments, the state governments in the South and in some southern states and the northern states were not going to, on their own, change their laws in order to, basically affect the promise of the 13th, 14th, and 15th Amendments. Because people have the franchise as of 1868, but guess what? They didn't really have the franchise until the 1960s and 70s, and in some states, in some ways, they still don't, right? And so guess what? The court stepped in. I'm not saying it's justifiable, but it's completely understandable. And if originalists can't accept that, then I think it's a problem with their theory, not that they, that sort of, it's really like too much water trying to go through a very, very slender hose. If you don't have the aperture wide enough, it's going to go somewhere else. And that's really what's happened with the Supreme Court. We had problems. Courts arguably shouldn't be the problem solvers. The legislature and the executive should be the problem solvers. They're most answerable to the people. But guess what? Those elected officials weren't doing it. And so the court steps in. And I understand the objections to it. It violates certain parts of our design, but we shouldn't be surprised.
Thank you.
Oh, I'm so sorry.
That's
See,
okay.
I forgot all about it. That's what happens when you take allergy medicine.
Dangling microphone here. Is it clip?
Which one?
There we go.
Sorry.
Okay, thank you.
Good.
That's the ploy. You dropped the mic.
To shake you out.
There's a lot there to respond to, but let me start from one point I think we can have a common ground on. I think most.
I don't want you to.
This is yours, and that's mine. Okay, very good. I think most originalists on the Supreme Court would agree that there are certain precedents that are not going back. But that's not really the debate that originalists wage today. The debate they wage today is what happens going forward. That is, should the court continue to extend non-originalist precedents to new circumstances? I'll give you a recent example involving Bill Cosby. A woman made an allegation against Bill Cosby that he sexually assaulted her. Okay? Bill Cosby's lawyer then released certain statements that she said were defamatory about her. Right? She sued Cosby for defamation. Now, you probably studied a case in torts called New York Times versus Sullivan. It's not familiar about defamation, right? And the doctrine says that if you're a public figure and someone criticizes you, you need to show what's called actual malice, that the person knowingly made this false statement. It wasn't reckless, it was deliberate. Okay. Now, the woman who accused Cosby, who sued for slander, wasn't really a public figure in any meaningful sense. But under some of the court's doctrine, she was part of a public controversy, which basically makes her a public figure. As a result, she would need to show actual malice, which she probably can't do, and Bill Cosby then would win on the defamation claim. Justices Thomas and Gorsuch wrote a dissent from that case. It was a denial certiorari. And they said, we are skeptical if this line of cases are correct as an original matter, that a random person who gets put into this public situation becomes a public figure. And because they're now a public figure, they can have their reputation slandered and have no meaningful recourse. Thomas and Gorsuch, they didn't say we should go back and reverse New York Times against Sullivan. They probably would, but they didn't say that. Instead, what they said is we should not extend those precedents further unless that extension could itself be justified by original meaning. And this is largely, I think, the path forward for originalists. We'll leave the past cases sort of water under the bridge, and then we'll scrutinize future cases. Are we willing to extend this doctrine to new areas? I'll give you another example you probably studied in common law, which is the Obamacare decision. During the New Deal, the Supreme Court had a number of decisions in which they read Congress's power very broadly, that Congress can regulate many types of local activity within a state. Come along the Obamacare case, and this case involved a mandate to purchase insurance. The plaintiffs argue that this law was not a regulation of activity, it was a regulation of inactivity, that we were doing nothing and they'd be made to buy insurance. Now, if you follow the tenor of the New Deal cases, this is fine, right? The Supreme Court in the New Deals and another case called Gonzalez versus Raich read these powers very broadly. But Randy Barnett, who is my colleague in a number of projects, had a phrase. He said, this far but no farther, right? In other words, we have the New Deal, we have Gonzalez v. Raich. Those cases said you can regulate all sorts of activity, or can draw the line and not go any further. We will not allow them to regulate inactivity. And this reflects a concept Randy describes as the gravitational pull of originalism. That no matter how unoriginalist a precedent might be, that there's this tugging force, that the original meaning sort of tugs you back and pulls within the scope of how far those precedents go. So I would consider it a victory for originalism not to overturn all these cases from the 50s and 60s and 40s, but going forward to exercise more caution in extending those doctrines. If I could just do that and persuade you that that's a viable idea, then I will have considered this event a success. Thank you so much. I'll just put this here so you'll knock my thing over again.
So Obamacare case is actually is a good example of what I was talking about, where there's a lot of disruption that is possible, and a kind of the flow of water through a hose that is too tight. So what ended up happening, if the originalists prevailed in that case, Obamacare would have been found to be unconstitutional without the individual mandate. Basically, the entire design of Obamacare probably would have been taken down. And so Justice Roberts, who is more of a, quote, problem solver, certainly not an originalist, found, and I don't think it's necessarily justifiable on a theoretical basis, it's not great jurisprudence, but he felt that the disruption of destroying Obamacare and tens of millions of people's expectations of having health care was too important. And so he found another solution, which had not been thoroughly briefed, and it wasn't joined, I believe, by any other judge, right? Which was saying that the individual mandate was a tax, and therefore constitutional under that provision of the Constitution. And all I'm saying is that having a justice, let's say like Justice Thomas, who is willing to take the stance of thus far but no further, but as a consequence create enormous disruption in the lives of people. All those people, right, who are getting health insurance who hadn't had it before, all those kids who were staying in the homes of their parents till they were 26, all the people with pre-existing conditions. Roberts basically said, maybe your theory is good theory, but we on the court have another job to do, which is not to create chaos, right? And you know, some of it has to do with a theory of what a conservative is, okay? I mean, it's not only a conservative is not only a person, you know, who abides by a particular set of political beliefs, and it may not be even a person who has a particular view of originalism. A conservative may also be a person who wants to conserve the stability of a series of social norms and social conditions, or rather than create chaos at the foot of good theory. And even, you know, Scalia, to his credit, he said this a number of times. He says, yeah, I'm a textual originalist, I believe in this, I believe in that, but I'm not a nut. And I think what he meant by that was he didn't feel that you needed to push theory to such a degree that you were willing to create really destructive and chaotic conditions among the people of the country. That, you know, being a judge, you're a human being, and there are real people in front of you who are not only the litigants and the people making the arguments, but if you have any kind of moral imagination, you're also thinking about all the other people who are not in that courtroom, but who will be affected by what happens. And that shouldn't be an insignificant consideration, right? And I know the argument is that having that consideration invites you to import your own values in as a judge and no longer do what judges should be doing, which is just interpreting the law as it was given to you. But as I said, our other parts of government have broken down. We've done a terrible job, right? Doing basic problem solving for the American people, whether it's at the federal level or at the state levels. And so it's inevitable. And as I said, this started happening in the 1950s. It's inevitable that the courts step in and in a not particularly, I don't think a particularly arrogant way or outrageous way, seek to at least preserve livable conditions for people, right? Allow them to go to school, allow them to keep their health insurance. And I think that's what John Roberts was doing. He's also worried about the future of the court itself, because the other problem he felt he had is that if he had voted with the other conservatives on the court on the Affordable Care Act, it would be interpreted as a political vote. That basically the 5 justices who had been appointed by Republicans were there to basically take down a piece of legislation that was essentially the hallmark piece of legislation of a Democratic president. And I think he worried about that. And, again, I think that's a conservative view, not in a political sense or a jurisprudential sense, but in a sense of worrying about the legitimacy of the institution itself. Does the court really want to be identified as being just one other political, bunch of political hacks who basically, vote with the, basically are, vote with the party that put them into that life tenured position. So I just think it's inevitable. The law is a product of human beings. We don't operate like machines. We aren't law machines. A lot goes into these decisions, including how it affects real people. And I don't think that the benefit of good theory and this idea that we can somehow divine what those words meant in 1789 should make us lose track of these other considerations that are very, very important.
Okay. Let's take some questions. Thank you. Thank you. Okey-doke. Questions? Yeah, Rich.
I do have a question for, I guess, Professor Norton, and I'd also like to read this as well. So, I'd like to read it as cats. So, cats certainly, I guess, in Lincoln's perspective, would water. The idea, we were trying to see in the Constitution. Could cats stand on stronger constitutional grounds if cats argued that privacy is a right retained by the people under the Ninth Amendment? And would you feel that that would stand and would have ground? And would that be something you would support?
Yeah, so if people don't know what Katz is, Mr. Katz is in a public phone booth, which don't exist.
Do they know what a phone booth is?
If they take my course, I talk about it all the time. So Katz is having conversations with his co-perpetrator in a gambling operation across state lines. That's why it's United States versus Katz. And the law enforcement puts a buck, electronic surveillance, a microphone on the outside of the phone, and essentially bugs, and they don't record his statements, but they transmit it to a police officer who writes it down. And so if you go to the text of the Fourth Amendment, your unreasonable searches and seizures apply to persons, houses, papers, and effects. It wasn't his person. He doesn't live in the phone booth, it's not his house. It wasn't his paper, and he doesn't own the phone booth, so it's not his effect. And it's Justice Black in dissent in that case said, this is just eavesdropping. Eavesdropping has never been a violation of the Fourth Amendment. Okay? Fine. So what the court in Katz did, and actually it's the concurrence in Katz, not even the majority in Katz, said, the Fourth Amendment is protecting, well, actually the majority says people, not police. And that what the Fourth Amendment really is protecting is privacy, your expectation of privacy. And that under Justice Harlan, the son of John Marshall Harlan, by the way, he graduated from New York Law School and a New Yorker, he said the test should be, is this an actual expectation of privacy, meaning subjectively, did the person really have this expectation? And then secondly, is it one that society is willing to recognize? Meaning, is it reasonable in society? Totally non-textual, totally non-originalist interpretation. Now, the Ninth Amendment argument, the problem with it is, like with a number of other amendments and provisions that are almost never used, is lawyers feel very nervous about arguing from sections of the Constitution that are just have no real developed case law. That's why Professor Blackman talked about privileges and immunities. The fact is that there was a time where privilege and immunities was supposed to be a vehicle for certain areas of law, and it was just essentially abandoned basically at the foot of the what was the case from the mid-19th century.
Slaughterhouse case?
Slaughterhouse case. So that's just an artifact of the legal system, that certain parts of the Constitution just end up becoming kind of dead wood. I don't think for any good reason really, that is it. So I think the best argument for cats that at least has somewhat of a textual sort of connection, or at least connection to the common law, is that when you're in that phone booth and you close the door and you put money in the phone, it's a temporarily private place, right? And we do have an expectation of privacy, for instance, in a hotel room where we pay the fee and we're there for a night. We do have an expectation of privacy in a hotel room where we pay the fee and we stay there for 2 hours. So, as long as we have the sense that the person has a subjective expectation of privacy, closing the door, putting the money into the machine, and that is one that a society is willing to recognize, we can also accept this theory of it is a temporarily private place, and therefore under the common law, what the police did was essentially a trespass. And that squares up with Jones, the GPS case, actually quite well, because the GPS cue ball, it's not a microphone, but it's a piece of technology that again attaches to what is otherwise a constitutional area. I do think that you can be creative and try to find a rationale that is closer to an original rationale, and that lawyers should try to do that. Because, as I said before, we are all originalists. It's not like we're a person who, like myself, who wants more flexibility, kicks the Constitution and its text to the curb. I always start with the Constitution, but I am not willing to, I'm not willing to just stay there.
The Carpenter decision from about a year ago is worth your study. Almost all of the opinions in that case, and there were several, laid claim to history. And Justice Gorsuch articulated what might be called a property or a positive model of the Fourth Amendment, which is indeed based on property rights. Katz is not the only Fourth Amendment test we have. We still have the old-fashioned property test. Katz is a supplement to that. So to the extent that this far and no farther works, okay, maybe you can leave Katz, but from now on you focus on other models to handle new cases.
Let me just say, Carpenter is very important. So that case has to do with cell phone locational information. So you have a cell phone. The company that you have your cell phone contract with basically maintains all of the locational information having to do with your proximity to cell phone towers. Okay, and if you're in an urban area, they can locate you, or the police, if they have access to that information, can locate you if they're looking to investigate your presence at the time of a crime. And that's what happened with the Carpenter. Then the question is, can the police just get a hold of that information directly from the cell phone provider with a basic subpoena? Or do they need a warrant from a judge? And the court in Carpenter split, right? There's a lot of opinions here. Say they need a warrant. And again, that's Justice Roberts. What's important about that is there had been prior cases, including a case involving a pen register, another case involving bank records, that if you have a commercial or any kind of relationship with another entity, like your bank records aren't in your home, they're at the bank, right? The phone numbers of people who call you and call that's all registered at the phone company. You have a commercial relationship with the phone company. Under those two prior precedents, you no longer had a property right to this information. It exploded, it forfeited. You already shared that information and essentially giving that information to the bank or your phone company. And that privacy tracks property. If you don't have a property right in something, you don't have an expectation of privacy. What Carpenter tells us, which is what Justice Marshall said in a dissent in the Smith versus Maryland case, is no, privacy is not an all or nothing proposition. You can have privacy and share it with other people within a certain close circle and still have no reasonable expectation that the police use it, right? And so we are in a position of developing law, partly generated by changes in technology and the way we live, where I would disagree with Professor Blackman that cats and the expectation privacy test is an adjunct or added on to the property analysis, even though historically, in terms of time, it is after. It starts, Silverman in those cases are early. But in terms of the cases that are generating the primary analysis now, it's mostly expectation of privacy cats analysis, either in the cell phone case or the Carpenter case. Right now, the non-originalist interpretation is driving the bus. And again, I think Justice Scalia, to his credit, kind of came to accept that, which is why his version of originalism, by the way, I disagree with Justice Scalia on a lot of issues, but on this issue, I agree with him. He accepted precedent, even if it was not originalist precedent, if he thought that it was, in the case of cats, essentially super precedent. Been around so long, we're so reliant on it. It's where the analysis really is coming from. Okay, that's the law.
Yeah.
Professor Dorfman, you spoke about the ossification of certain laws under a originalist framework. Could you compare that to what some legal scholars call a crystallization of laws, which just give the law more teeth and has more of a positive connotation?
Obviously, the promise of originalism is clarity and certainty. Right? This idea that somehow we can figure out what this language is, the public meaning of this language came out of things that happened hundreds of years ago. First of all, that we'll be able to define that through various processes, canons of construction, historical evidence, whatever, dictionaries even. And yes, to the extent, if that was true, if I felt that that promise was true, then this metaphor of crystallization is a good metaphor, because it would be, quote, crystal clear. First of all, I don't believe that a lot of the most problematic language in the Constitution is subject to that. Most of it is, as I said before, vague, ambiguous, and polyvalent, and really resists that kind of crystallization. My fear of ossification is that this idea of this far and no further, right, whatever Professor Barnett's precise language is, the risk of it is the fact that the law becomes less and less relevant in being able to respond to new circumstances, and given the fact that our democratic processes, our Congress, our executive branch, even many of our states are not doing a very good job of, and I'm going to use the word problem solving, inevitably the courts are going to do it. Not necessarily because they should, but somebody has to, okay? I mean, the idea that we can allow private parties and the market to solve these problems. I think, when we talk about healthcare, plenty of this stuff, I think that is just not, it's not credible. And so whether you believe in government or not, right? And I know as a libertarian, if you're a libertarian, you're mistrustful of government, you worry about the government. And I appreciate that completely. But the fact is that we have really some very serious problems. And and the market is certainly not solving it. We end up looking to government to solve them. And if the legislature and the executive isn't doing it, we've learned a lesson, and it's been going on for a while now, that the courts will maybe not do it very well, by the way, but they will step into the breach. I think it's predictable, it's inevitable. Nobody wants to live a life where this kind of situation just persists, because everybody is, and I'll use the word ossified, paralyzed by ineffective institutions.
All right, maybe one more question? Anything? Going once? Going twice?
Hoover. I guess from your perspective, how does the Ninth Amendment and privileges or immunities clause play into originalism? I mean, the idea of rights retained by the people, as Grant Barnett definitely talks about. So how do we find these rights retained by the people? And I think that's something that an originalist can certainly grapple with, because what are these rights?
Mhm.
And certainly there's many of them, but do you think it's a challenge to an originalist theory of the Ninth Amendment that we don't know what all the rights are?
Sure. So there are two provisions of the Constitution that Rich mentioned. The first, the Ninth Amendment. And I'll just read it to you. It's fairly short. It'll take me a moment. It provides that. Okay. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. There are different ways of reading the Ninth Amendment. One is it's merely a rule of construction. If you remember your contracts class, remember the expressio unius canon, that if you exclude some things or you include one thing and not the other, you shouldn't take that to mean, I said that completely wrong, that if you include some stuff, you should take that to mean you're trying to exclude other stuff, right? The inclusion of one suggests the exclusion of something else. The most simple reading of the Ninth Amendment is that it reverses that presumption, that the mere fact that some rights are enumerated doesn't mean that other rights are excluded. Now, easy enough to say. What does that mean? Does the Ninth Amendment allow judges then to then decide if a given law runs afoul of what the rights retained by the people are? Who knows what the rights retained by the people even are? My colleague Brandon Burnett, who's one of the experts in the world of the Ninth Amendment, argues that this provision, the Ninth Amendment, reverses certain types of natural rights, those that we came from the state of nature with, and that if laws run afoul of them, that the courts are empowered to actually set aside laws. And this is a fairly lengthy theory, which I can't do justice to in my remaining 2 minutes. The other provision Rich mentioned is the Privileges or Immunities Clause of the 14th Amendment, which provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizenship, that one of citizens of the United States. Okay? Okay, that's fine. What does it mean to be a privilege or immunity of citizenship? Now, again, Randy has a lot of theories on this, and this is fairly contested. I find Randy's theories persuasive, but I think it's not ironclad. That this concept of privileges or immunities was a term of art in the 19th century and referred to certain kinds of what we now call fundamental rights, rights to own property, rights to bear arms, right of free expression, right to own property, right to make contracts, and the like. If you look at some of the civil rights acts passed in the wake of the Civil War, they expressly protected these types of privileges. If that's the case, then that the courts would be empowered to set aside state laws that run afoul of them. And also Congress would also be empowered to create causes of action where people can sue their states who deprive people of those rights. In fact, Section 1983, which you probably know very well, was based on a similar principle in the 13th Amendment. Now, originalists love these provisions because they do have a way to ascertain rights that are not enumerated. The courts, both left and right, have taken very stingy views of the Ninth Amendment and an even stingier view of the Privileges or Immunities Clause. I would love it if the justices were willing to give some teeth to these clauses. Justice Thomas has written a bit about privileges or immunities in a case called McDonald v. Chicago, another case called Timms. Justice Gorsuch hinted that he likes PRI. We'll see about Justice Kavanaugh. Maybe he's still on the fence. I don't know. But I would love for the justice to give these provisions a little bit more teeth.
If lawyers aren't arguing from these provisions before the courts, in other words, if I'm a lawyer and I'm making an argument in the federal district court and then in the Second Circuit, let's say, and then over to the Supreme Court, and I'm not using the Privileges and Immunities Clause or the Ninth Amendment, then you may get somebody like Thomas or Gorsuch who will import into the analysis in a concurrence or dissent the analysis, but it's never going to be part of the rule of the case. So you need the lawyers to begin to see this as an effective tool for argument, and the just don't see it as a winning proposition. And it's interesting because you end up having a whole group of academics. By the way, Professor Barnett was my professor back when I was in law school. He was a wonderful teacher. But you have academics and then some judges who will come out of the Federalist Society who are very excited about these essentially unused parts of the Constitution and see if it contains some possibilities. But until lawyers actually start making these arguments and they become part of the primary argument in these cases, it's not likely to happen. There was some playing around with privileges and immunities in black in a number of concurrences, trying to use it instead of due process. Ninth Amendment, I believe, was discussed by Justice Goldberg in the Roe versus Wade.
Griswold.
Was in Griswold, right? One of the privacy cases. So there have been judges in the past who have played with this. But remember, all of this language has been in the Constitution essentially forever. And nevertheless, for whatever reason, lawyers aren't using it. And at a certain point, there are parts of the Constitution that cease to have any real weight.
Oh, don't say that. I'm kidding. I'm kidding.
That's a practical matter.
All right. We've detained you long enough. It's unreasonable at this point. Thank you all so much.